Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. So this is the second video in my law school section on different things about law school and how you survive law school and what you do in law school. Today we're going to talk about the legal essay exam. Essay exams are the way that most law schools evaluate their individual students, and they are competitively graded. Your class rank obviously affects your employability after law school. It also affects whether or not you wind up on academic probation or some other measure that might wind up getting you kicked out of law school. There are all kinds of reasons why you want to do very, very well on your essay exams. And if you go into an essay exam without a plan, without a method of attacking the problem, it can really seem overwhelming at the outset. So today we're going to talk about a contracts exam. And we're going to do that in the context of a hypothetical question, one that was used, I think, at NYU Law School. And I'm going to break it down with regard to how I would attack this particular problem. And hopefully that will be of some value to people who are in law school and who have to deal with this kind of thing. So without further ado, let's take a look at how you get a better grade on a legal essay exam. So to begin with, we start with understanding the call of the question. What is it the professor wants to know? What does he want you to tell him on this quiz? Use scratch paper, first of all, to spot the issues. You want to have a piece that you can write and make notes on. And if you have a highlighter and if it is okay with the professor for you to write on the tests, then you can make these notes on the test paper itself. But I always used a piece of scratch paper. Don't start writing the answer until you've read through the hypothetical twice. And the first time you read through the hypothetical, what you're looking for is the call of the question. So you find the call of the question, then you start spotting issues, and then you discuss the issues. And after you've fully responded to the call of the question, then you can look for any additional issues and discuss them if you think that your professor will reward you for doing that. So it's really important to use your time wisely. Now here we know that the exam has 2 questions and 5 pages. Both questions are weighted equally, so 50% of your grade is going to be based on each of these 2 questions. You have to allocate your time accordingly. You get 3 hours to complete the exam, which means basically you have an hour and a half to actually do the 2 hypotheticals. And you have to bide your time. You have to make sure that you budget enough time to finish both questions. The rest of this we're not going to go into because it's peculiar to that law school, but you do want to make sure you understand the rules, particularly about blind grading and that sort of thing. So here is the call of the question. It says, at the very bottom there, it says who's suing him. You know, we've got Todd Chester is suing him, and Rocky and Eddie are suing him as well. So you got 3 people who are suing him. You have to discuss the claims against Clark. That's what you're going to have to do first. And then what legal options he, meaning Clark, might have. It's a poorly written question if you ask me. At any rate, that's what you're going to be required to do. So now that we understand the call of the question, we can start looking at the question and making some notes perhaps. So I want to point out it's very important that you follow these rules. So here's question 1. It says Clark Griswold, the Willy Loman of the food additive industry, was planning a huge Christmas holiday. He went to see his boss. Now remember, it doesn't say owner here, it says see his boss. His boss may not have the capacity to contract for the company. So when a professor uses a word like boss, you need to be careful, because if you assume that the boss has that authority to make a contract, even though there is no contract here, if you assume that, you're going to be in trouble. So what you have to do is make sure you note that the hypothetical says that Mr. Shirley is the boss, but that doesn't necessarily mean that he is the owner of the company and has the authority and the ability to contract with employees. Again, very important points. So the things I look at here on this hypothetical are whether or not the question is actually specific enough to be of any use to Clark later on. I make a note that it's vague and I move on. Now, when he answers the question about Christmas bonuses, he says, "We've always shown our appreciation for our employees during the holidays. As you know, we always will." And that's not a promise. It's vague. Clark asked a vague question: would there be Christmas bonuses this year? He didn't even ask if he would get a Christmas bonus. It said, will there be Christmas bonuses? So he asked a vague question, and now he's getting a vague answer, which is not a promise. We've always shown our appreciation, and we always will. Showing your appreciation, obviously, is different than actually giving somebody a monetary bonus. So we move on down. It says Clark entered into an agreement with Rocky's Pools to do an in-ground pool. Rocky agreed to do the job for $15,000 with construction to begin immediately. So we're looking now at damages issues because we can we sort of have the idea, since we've already read through to the call of the question, that he's going to essentially breach the contract with Rocky. So the $15,000 immediately pops up as a damages issue. We write that down. And then we look at the fact that Rocky is going to have to mitigate his damages. And so even though he's only spent $5,000, that's money that he's spent that he's out of pocket. That's certainly going to be an element of damages. But what about the $9,000 he would have to spend? Well, he's not going to have to spend that. He can mitigate those damages, which means he's got $5,000 in actual damages. And then he turned down a similar job where he expected to make a profit of $3,000. So probably the damages at this point are $8,000. But we don't have all of the facts to the hypothetical yet, but that's what I'd be looking at this point. And so when you look at this, you want to make a note that you're looking at expectation damages, the loss in contract value, plus the other loss, minus the costs that were avoided, minus any loss that was avoided. Those are expectation damages. You'd need to kind of make a little brief note of the equation right there so that you remember to write that in when you start writing the answer to the hypothetical. So then he goes to the Christmas tree farm and he says, pick out your favorite tree, only $100. Now, the sign at the entrance says this, but no one at the lot, according to the hypothetical, says this. That's just what it shows on a sign. A sign at the entrance said that, but it doesn't say that Clark read the sign. He had to race another shopper to a tree, and what does he do? Well, first of all, is this an offer? It could be an offer if it's accepted, but again, we don't know that Clark has actually read that, so we don't know whether it's an offer or not. We want to make sure we put that in the answer. He comes to the tree and says, beats another person to it and says, it's mine, back off. But then he realizes he didn't bring a saw, so he goes home. And is he accepting an offer by performing and grabbing the tree and claiming and saying it's mine? By virtue of doing that, is he essentially accepting the offer from the sign at the front? Again, we don't know, but those are issues that we've spotted, so we make notes of those and we move on. And then when he gets home, he discovers a Christmas tree on his doorstep. And the question here might very well be, what would a reasonable person do if they found something on the doorstep? Would they think it was a gift? Well, they might. It's the Christmas season. It might be a gift from someone. So I would make a note about the reasonable person and move on as I went through the hypothetical. So he has his guests arrive and the squirrel gets loosed and Clark says, I'll give $1,000 to whoever catches that squirrel. It's a very clear offer. $1,000, catch the squirrel. So his cousin Eddie, who could use the money, puts on goggles and gloves, gets a fishing net, and goes looking for the squirrel. And then Eddie's wife says, hey, Eddie loves to eat squirrels, and that appalls Clark. So he says, never mind, I'll catch it myself. So do we have an offer? Perhaps. Did he accept it by performing? He may have accepted the offer, but he hasn't performed yet. And the offer was, I'll give $1,000 to whoever catches the squirrel. Well, in order to perform, you have to catch the squirrel. So before he can catch the squirrel, Clark withdraws the offer. So with the offer withdrawn, before acceptance was complete, that could create an issue of quantum meruit, meaning as much as the thing is worth. Maybe he has a claim under quasi-contract. Then we move on to the 4-week-long tickets to Euro Wally World. Again, this doesn't have anything to do with the claims against Clark. It might be important when we discuss his legal options, but it's non-refundable. They're mentioned as being non-refundable, and normally when you buy something that is non-refundable, you take the risk of it not being refundable to you. So Lambda Airlines kind of goofs him up on the tickets, and they told him that the terms and conditions on the website, the company had reserved the right to cancel the tickets. So again, it probably doesn't have anything there, but that might very well be unconscionable, particularly if they did not refund his money on the tickets. And is it a contract of adhesion? Is the airline liable for consequential damages? All of these things are built into this hypothetical, and the professor is going to expect that you discuss these things. Then we find out that Clark didn't get a $10,000 bonus. He got a subscription to the Jelly of the Month Club. No doubt getting something like guava and what are those awful? Oh, gooseberry. Probably gooseberry jam. There you go. Clark immediately phoned Rocky and told him he'd have to cancel the job and stop construction. And then so we get down here and it says, Art from the tree lot has brought an action in small claims court against Clark for $100 for the tree Clark picked out at the lot, even though someone else bought it. So, first of all, it's a bummer that he's getting a subscription to the Jelly of the Month Club. It's probably a breach of contract issue. There's mitigation of damages issues that we talked about a little bit earlier. Then here, because somebody else bought it eventually, there's no damages. So the claim in small claims court is not going to go anywhere. We know that. Again, because somebody else bought it, no damages. Clark's neighbor is suing him. It turns out the tree left on Clark's doorstep was supposed to be delivered to Chester's house, but the delivery company made a mistake. Clark's neighbor can sue him. You can sue anybody for anything, but he's unlikely to recover against Clark because Clark did not go take it off of Todd Chester's porch, which would be conversion, which isn't really a contract claim, it's a tort claim. If anything, Todd has a claim against the delivery company, not against Clark. First of all, the things that need to be discussed here is that there's no privity of contract between Todd Chester and Clark Griswold. There has to be privity of contract if you are going to sue somebody in contract. Do you have a quasi-contract claim? That's possible because Clark was unjustly enriched. He did not have to go and buy a tree. A tree was delivered. He never bothered to find out why or how he got it. Was he unjustly enriched? And again, you discuss that issue and you move on to conversion if you think that's going to boost your grade. So that's how you go about analyzing it, and you pay attention to what the call of the question is. And again, Rocky has a breach of contract claim. That's the first thing you discuss. Then Eddie has a potential breach of contract claim. That's the next thing you discuss. You can discuss Todd's claim against Clark. That's the third thing you should discuss. I'm talking about structuring your answer here. And then when you're done with that, you go back to the top of the hypothetical and you discuss whether Clark might have a potential contract action against Mr. Shirley. And of course, he doesn't because the promise was vague, if it was a promise at all, and there's no consideration. Clark didn't do anything extra to merit the bonus. He would get a bonus as a gift, and there is no contractual issue in getting a bonus when it is simply a gift. There's no consideration. So all of those things, you would come down and look for possible claims that Clark might have. Clark might have a claim against the airline. He probably does not have a claim against Euro Wally World. And then when you had all of that lined out, you would then outline an answer on your scratch paper, and then you would start writing the answer. It should take you about 30 minutes to go through this and outline it and get all the issues spotted and think about it. And then it should take you about an hour to write it. So at the hour and a half mark, boom, you move to the next question. Legal essay exam writing is an art, and probably the best way to practice for this is to go get prior hypotheticals and prior exam questions. Almost all professors have prior exams that they have given in years past that they are not going to reuse, and so they give those questions out so that people can practice with them. And the best way to practice with them is through a study group. So you get your question, you take your hour and a half to answer it, you write all your answers out, and then you exchange papers with somebody in your group, and you grade theirs by looking to see whether or not they missed any of the issues that you got. And you also look to see, oh man, he spotted an issue I didn't spot. That's important. I need to remember that. And go through and you practice this 3 or 4 times in each course during the course of the semester, because it is the thing about the law school exam is it's your final grade in that course. So as soon as you can start getting exams, you need to start looking at those exams and practicing on the writing of them. Now, again, you're not going to have to cite cases. You can certainly do it if you want to, but you're not going to have to know the cases or the citations or any of that. All you're going to have to do is spot the issues, discuss the issues. One thing that's really important, I think, is not to speculate. Don't say, well, it could be that there was a clause in the contract that said this or that. You don't want to do that. You don't want to add anything to the hypothetical, but you also don't want to miss anything. For example, with Mr. Shirley being the boss, that is something you don't know. You absolutely don't know if he is the owner, and you would point out that you don't know that and that it might affect your analysis if he was the owner. And you always use weasel words, because lawyers like weasel words, and you say things like it might affect your analysis. You don't say that it would affect your analysis, because that implies that there is a cause of action there when there may not be. So hopefully you found this somewhat helpful in terms of being ready to take your exams. I would point out that there is an excellent program out there by Wentworth Miller. It's called the Legal Exam Essay Writing Seminar. And I believe it's available on audio tape. It may be available by Zoom. It may be available to attend in person. The essay exam writing course is an excellent course to take. I took it after my first year exams. At the end of my first year exams, I was in the top 20%, and I took it, and it improved my grades immediately, and I wound up graduating number 7 in my class. If I'd had that preparation beforehand, I might very well have been up at number 2 or number 3. So I offer that for whatever value it may be. You can find that on Amazon. I'm not endorsing it. I'm just telling you that it's there and that it is a good product. That's what I have for you today. Thank you so much for watching. Hopefully you were interested in this, and hopefully you'll find it helpful. And if you have any questions, drop them in the comments down below. And if you have the opportunity, do a kindness for someone today, and then come on back tomorrow and join me at the beach, and we'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.